Good morning and good afternoon, everyone. I'm Kimberly Best Robidoux with WR Immigration, and I'm here with my partner, Carrie Koski. We are excited to talk about worksite preparedness, I-9 E-Verify and immigration enforcement, what to know, part one, which implies that there is a part two. So, yes, we are going to have a part two coming March 12th, and we'll give a little bit more information about that as we move along through part one. All right. Again, I'm Kimberly Best Robidoux, a partner here at WR Immigration in the San Diego office. I'm also currently chair of our American Immigration Lawyers Association Verification and Documentation Committee, which is the committee that liaises with the government agencies that oversee worksite compliance, including USCIS, IER, USCIS E-Verify, and that lovely agency ICE. I'm going to turn it over for my partner, Carrie, to introduce herself as well.
Thanks, Kimberly. I'm delighted to be here today. I am the managing partner of the Denver office for WR Immigration. And I work with Kimberly as we work through these worksite enforcements, primarily in I-9 compliance and Department of Justice, Department of Labor investigations. And today we're going to talk to you about this new frontier, which is really a revisiting of some of the prior conditions that we faced under the last Trump administration.
So, because we're lawyers, we always want to provide a legal disclaimer. So, this does not constitute legal advice. Our discussion today is for informational purposes only. And if you require any legal assistance or legal opinions based on a particular situation or your particular organization, please reach out to us and we'd be happy to help out. WR Immigration, we're all about the journey forward. So we partner with our clients in order to provide them with the best experience with strategic legal advice and services, our technology, and collaboration. And we're excited to be here today. So, roadmap. First, we're going to talk a little bit about executive orders, ICE enforcement actions, ICE HSI. So, ICE is Immigration and Customs Enforcement, and HSI is Homeland Security Investigations, which is a part of ICE that does the actual worksite enforcement. And then we're also going to talk about state investigations based on the state mandated E-Verify enrollment. Okay, so just to get us started, the relevant agencies that we're talking about today are USCIS, which is United States Citizenship and Immigration Services. They oversee the petition verification as well as applications. But for our purpose of our discussion today, they oversee the Form I-9 and E-Verify process. They create the policies, the rules, the regulations, and all the guidance that is related to the Form I-9 and E-Verify. And that Form I-9 is the employment eligibility verification form, which all employers are required to complete for active employees in order to verify their identity and their authorization to work in the US. The second agency that is involved in our discussion today is US Immigration and Customs Enforcement, the Homeland Security Investigations, which we refer to as HSI. So they enforce the policies, the rules, and the regulations that are related to the Form I-9 and E-Verify programs, right? So USCIS creates and HSI enforces. So we're going to focus on these two agencies today. Okay, I'm going to pass it over to Carrie for executive orders.
Thanks, Kimberly. And so we can go to the next slide. And Kimberly outlined the two agencies that we're going to focus on today. And there are several more agencies involved in the executive orders or impacted by the executive orders that were announced on January 20th. But because of the extensive impact of the January 20th executive orders, we've created a series. So this is the first of a two-part series, and the second part will be on, what is it, March 11th or March 12th?
March 12th.
March 12th. On March 12th, we will follow up with the balance of the agencies and walk through what we don't cover today. And there's so much content and so much to share with you all. But please put your questions in the chat. We will get to them if we can, and then we'll also follow up with an FAQ, and we'll try and get to your questions when we send the deck out as well. So in terms of the executive order that was announced on January 20th, called Securing Our Borders. What it did is that it allocates additional resources to the different agencies. So what we'll see is increased USCIS and fraud and detection, the FDNS site visits, which targets employers to really verify the information in those petitions that you file to the Department of Homeland Security. In addition, we'll see Department of Labor audit and investigations. So we'll want to make sure that our record keeping is zipped up for H-1Bs and perm. And then we do expect more notices of inspection or I-9 audits. And then what we've seen a lot of media about, a lot of buzz about, and really the most intense impact on for the past couple of weeks is those ICE raids or those door knockings. And then anti-discrimination or labor exploitation, which we saw a lot under the prior administration. We do expect to see sort of the flip side of that, which is prosecution of discrimination of U.S. citizen under their PERM program. So it's a multi-agency sort of push and effort to prosecute violations under the immigration laws under these multi-agencies and through executive order under existing statutes and regulations. So um, in terms of best practices, what we can do to get ahead of these executive orders and some of the things that we know that you're already doing, and if you're not doing, we'll help you plan to do those, is do regular audits of your I-9s and your public access files, compliance reviews, update policies. If you haven't looked at your I-9 policies or your document retention policies recently, it's a good time to pull those out and update them. Train your staff. Make sure that your receptionists, those folks that sit in your public areas or even next to your back door, are trained as the first point of contact to any government officials. And then also, support your employees. Provide them with basic information on what to do if they are contacted by a government employee conducting an investigation. You can go to the next slide. So let's talk about worksite enforcement actions. And here we're talking about those multi-agency actions, but we'll talk about ICE enforcement actions first. And these are those door knocks, right? These are those ICE raids, quote unquote. So here we know that federal agents can enter public areas of the workplace. But they must have a judicial warrant. And there are two types of warrants. One is a judicial warrant signed by a judge, and the other is a administrative warrant signed by any agency official. Now, you do not have to consent to an administrative warrant. You can reject that. But you do have to allow a judicial warrant. You can object to parts of a judicial warrant and note that objection and carry that out later during the investigation in terms of not consenting to the search. But if you do receive a judicial warrant, you do have to allow the search. We can go to the next slide to see some examples or to see an example of an administrative versus a judicial warrant. Now, you might not be able to see this because the font is really small, but this is an example from the Colorado Immigrant Rights Coalition. On the left is an administrative warrant. This warrant is signed by a Department of Homeland Security official. So this is not a warrant that has to be accepted On the right is a warrant signed by a judge. So this is a warrant that you would have to accept, allow the officers to come in and search. Can go to the next slide, please. So, action plans. Currently we're helping companies create action plans. There is a clear course of action or sequence on what to do if ICE comes knocking. The first point of contact, the person sitting next to the front and back door, the public facing employee. And this may be somebody who typically will greet members of the public. And you really want to have them walk through sort of a checklist in their mind, right? Or maybe they have a checklist in their drawer, but they need to be prepared on how to deal with the federal agent, especially if you're a business in one of those sort of high risk industries like manufacturing, food packing, and other type of industries where we're seeing raids. And then you want to provide that person with guidance on the types of warrants and even examples. We can go to the next slide. So, in terms of action plans, you want to also provide questions, sample questions that the agent might ask. And when somebody comes in, when somebody who looks like an ICE agent or law enforcement comes into your place of business, you always want to confirm are actually who they say they are, that they're not some vigilante name, their badge number, their contact information, and just review their documentation. We usually confirm with their business card. We'll ask for their business card. If the agent doesn't have the document, we'll say, well, want a vigilante to come in. All right. Sorry, it looked like I had a unsecure network there. Um, so that person should also notify the executive team and the outside counsel immediately of that investigation. And if a judicial warrant is presented, the front desk or receptionist should comply, right? If the warrant requests and for equipment documents, then those items need to be presented. It's best practice for the officers to be accompanied around the premises and for notes to be taken. You can even videotape the investigation and to better understand and to also relay that information to outside counsel. And then the company representative should also ask for a list of seized items or to make a list of the seized items during the search. You can go to the next slide. Um, so the company representative does not have to give any statements and should not give any statements without consulting an attorney. That can be done later, right? The warrant uh, contains specific information that it is directed at, and the company representative probably isn't one of that specifically designated items. So the company representative should not volunteer information. Um, and then other employees should not volunteer information either. And then, of course, never hide information, never conceal information, um, and never never help employees leave the premises. Never um what how do I say this? If an employer is providing support to somebody that's not authorized to work in the United States, that could be deemed harboring or aiding or abetting, and that employer could be deemed. It's very important that the employer draw the line Of course, employers often have close relationships with employees, but you really need to also protect yourself when you are in instances of raids, and advise your employees to get their own legal counsel in these situations. Think, yeah, I'll hand it back over to Kimberly.
All right, Carrie, we had a couple of questions. We was talking about if an officer visits with a judicial warrant, is it still permissible to deny entry, ask to mail the warrant, and schedule an appointment with the appropriate person from the company? Um, do you want to answer that question or you want me to dive in?
Yeah, I mean, we can both answer it, but if it's a judicial warrant, then you actually have to admit the person. You should review the judicial warrant because the warrant needs to list the specific items that are being searched and seized, and the law enforcement officials cannot go beyond the scope of what's listed in that warrant.
Okay, so we have another question that we can bring in here too. It was mentioned that an organization doesn't need to provide access to agents that present an administrative warrant. How do you recommend approaching that conversation and what would a person say in that kind of situation? I would do
Yeah.
you want to go ahead?
No, you do.
So every situation is different. Typically, if an administrative warrant is issued, the company representative may say, I'm going to think you can accept it. Talk to your attorney with respect to how the company or organization is going to respond to that warrant. In some situations, it might be okay to reply. It might not be a bad thing to comply with the administrative warrant for the what's being requested with respect to documentation or information. But there might be situations where an organization might push back, and that is an appropriate pushback, which is to have the agency obtain a judicial warrant. And in that case, the agency has to go before a judge and explain why it is necessary for that information or documentation. So administrative warrant do not need to comply with right away, but it's best to, in all those situations, to reach out to an attorney because each situation can be different.
Right. Yeah. I mean, in terms of an administrative warrant, it's often for the arrest of an individual, and the removal of an individual. So if the ICE officer is wanting to come on premises, mm, I mean, the employer can look at the warrant and say, this is an administrative warrant. You need to get a judicial warrant. I think that would be a really tricky and difficult conversation, right? But definitely get legal counsel involved.
And if that administrative warrant is asking for a particular individual, again, the employer does not need to provide that information directly if it's a request from an administrative warrant. So again, anything like that is recommended to discuss with immigration counsel because as Carrie had mentioned, it's also balancing the situation where the government could potentially perceive that the organization is harboring an individual if they know that that individual is undocumented and they're keeping them away from the government agent. So it's a fine line to walk and definitely something on a situational basis to discuss with the attorney. One of the other things just to mention is as the government agent, if they have a judicial warrant and they're going through the premises, it is perfectly fine for an employer representative to be there to follow them, to videotape, to look at what's being taken. They can potentially ask for copies of the documents. The government agent will probably not permit that, but make a note of what's being taken and review what is listed in the warrant so that the agents don't go beyond the scope of what's stated in the warrant. If they do, the representative can make a comment, hey, you're beyond the scope of what's permissible in the warrant. Don't get it into any arguments or any fights. If the government continues this before an attorney, if an attorney is not there, if the government continues to go through and not heed what the representative said, take notes of that. And then that could be grounds for a complaint or for dismissing action in the future. So those are employer rights and responsibilities. And then we'll flip over to employee rights and responsibilities. Right. So employees have the right to remain silent and the right to an attorney. The company representative who's there should ask, and this is if there's a judicial warrant, right? And so the agents are there, the company rep should ask the agents if employees are free to leave. And if employees are not free to leave, then they have an absolute right to an attorney. Employees don't need to answer questions about their immigration status or where they were born or how they entered the US, and they can refuse to show identity documents. There are some state laws that vary, so it's also important to review what is applicable in your particular state with respect to any document that might be required to be presented, such as a driver's license or an ID card, but a foreign passport may not be something that is required to be presented to government officials. If someone is in the US legally, like an H-1B status or L-1 or TN, then, one of the things that they can do is present their foreign passport and I-94 document as evidence that they are here lawfully in the United States so that they don't potentially go into that next step of being detained, right? So they can present that information. And then if any employees are detained or taken into custody, you want to ensure that a company representative notifies that employee's emergency contact. And then the other thing to think about is that a company is required to pay wages that are owed to that detained employee. And again, that would likely be working with that emergency contact to ensure, how that is going to be paid to the employee who's detained. Okay, next slide, please. All right. What to expect in an HSI work site enforcement. So, HSI may conduct surprise audits. As we mentioned, they can enter public areas, but need actual consent by the company representative or judicial warrant to go on into private areas. And then it's also essential that employees know their rights and that these types of enforcements can continue for months beyond the time that the HSI agent shows up on the premises. Right, next slide. So with HSI, outside of an I-9 audit, they can also issue an immigration enforcement subpoena, in which case they are typically asking for documentation that could be personnel records, it could be payroll records, various information that they are requesting for an enforcement subpoena that is outside of an I-9 audit. That is something that the company should review with an attorney to determine, should we provide this information and documentation, or should we push back and ask HSI to get a judicial warrant for this information? The document on the right, which has the redacted information on it, is an immigration enforcement subpoena that is typically attached to an I-9 notice of inspection. And when this is included with an I-9 notice of inspection, then the company does want to provide this information and documentation to ICE. There might be some situations where certain documents might not want to be presented, but for the most part, they're typical payroll records in order to make sure that the company is presenting Forms I-9 for all active employees and that they can verify the start date. So these are, different, slightly different situations, but things to look out for. And I'll pass it over to you, Carrie, for the actual I-9 audits.
Sure. Thanks, Kimberly. So, in terms of HSI, the classic worksite investigation is an I-9 audit. And it's what Kimberly and I spend a lot of time advising on. Because, immigration compliance actually boils down to this I-9 that every employee in the United States fills out within 3 days of hire, right? And so we absolutely expect a surge in enforcement around I-9 compliance. And what that means is that it'll probably be in targeted areas and in targeted industries. So, where there, are higher risk employees, meaning that employees that may be losing their work authorization or are already working without authorization. And we know that, um, under the executive orders and in recent announcements, certain people who have TPS will no longer be able to extend that TPS or their work authorization. And certain people who are admitted to the United States via humanitarian parole will no longer be able to extend their work authorization. So, thousands and thousands of people will be eliminated from the workforce, right? And so these workforce investigations will reveal that there are potentially people that are not authorized to work via looking at at I-9. So it is important to audit your I-9s to ensure that um, those folks that may have expired work authorizations don't continue to work or have alternative, those are more vulnerable industries. And, for example, I'm being told my internet connection is unstable again. For example, in 2022, we saw double the amount of I-9 audits than in 2023 and 2024. And we do expect that the I-9 audits to come surging back with these executive orders. And we can go to the next slide. A sample notice of inspection, this is really simple document. It usually has an attachment with a list of items that it's requesting. We can go to the next slide. So the Form I-9 process, I love this grid because it's just like it looks really complex, but it's actually not that complex. So typically you get an I-9 notice of inspection, and within 3 days, an employers are required to respond. If you have outside counsel, you can ask for an additional period of time to respond. Um, if in your response, there are a number of I-9s that appear to have people that are not authorized to work, uh, Department of Homeland Security will issue a notice of suspect documents, and there may be individuals who, either need to supply legitimate documents or are terminated. Notice of discrepancies, where an employer will have to resolve those discrepancies, sort of like suspect documents. Um, and then an employer who has multiple substantive and technical violations will often receive a notice of intent to fine. And those can be in the tens of thousands or hundreds of thousands of dollars if I-9s are not compliantly stored and are completed. And so these types of situations can result in ramped up penalties very quickly. We can go to the next slide. Like I mentioned, civil fines, penalties, even criminal penalties. And I'll hand it over to Kimberly to talk more about the consequences of sloppy I-9 compliance.
Great. And, Carrie, before we get into the nitty-gritty of penalties, we have several questions here that I think it's kind of timely to answer those.
Mhm.
So one, which goes back to when we were talking about warrants outside of I-9 audits. What if the warrant is defective or it lists the wrong address, for example? So typically, if a warrant is defective, it can be stated as such, and the agency usually needs to have that defective nature of the warrant corrected. Again, speak to counsel with any particular issues that do come up, but that is definitely something that can be and should be corrected if the warrant is defective. If this is under the prior section that we were talking about with warrants, if they ask for a file, can we keep a copy or give them a copy? So in that situation, it depends on how the agents are going through. If it's a judicial warrant, they might not give you time to make a copy. So if they take everything, note it down what they've taken, but it definitely can be asked to make a copy before they take those documents or files as part of the search warrant. Do they seize I-9s? What kinds of things do they seize? So under a situation that is not a normal I-9 audit, they could have a lot of documents on their list, as some of those could be the Forms I-9, in which case that's a situation where you can ask if you can make a copy of those I-9s in the course of a judicial warrant, and they may or may not permit that. So you want to make sure that you have essentially an inventory or a receipt of all the documents that are removed from the premises during the course of a judicial warrant. And again, be very clear about what is in that scope of the judicial warrant so that you can keep track of what is being taken, what is not being taken, and what can be argued with respect to as being inappropriate. How do you manage situations where files are in electronic format rather than a hard copy? And how do you ensure they are handled in a timely manner in a remote work environment? Carrie, do you want to answer that one?
Sorry, I was on mute. So this is a great question. In terms of electronic I-9s, uh, I mean, as long as the I-9 is scanned and properly stored, and we do actually walk through that in a couple of slides. But these days, um, I-9 software actually has some great functionalities in terms of audits. And you just want to make sure that if you are auditing and you're doing it in a fashion that you're making sure that your electronic storage is compliant and that you're going through section 1 and 2 and in terms of the remote hires, you wanna make sure that you were COVID compliant, and then that after the COVID flexibilities, were expired, that you either adhered to the alternative procedure. And one of the things about the alternative procedure, you wanna make sure that you did the video verification in addition to reviewing, the photocopies. That's a really long-winded example and probably too detailed. These are great questions, but I think we have so many slides, we should probably get back to the slides.
Yeah, I just wanted to go over those because I thought they were pretty good and relevant. Okay, so and we'll come back to these if we definitely have time, and if not, we'll be sure to answer them afterward. So, civil penalties. The fines keep going up every year. They're posted in the Federal Register. So, for I-9 paperwork violations this current year, the range for the fines are from $288 to $2,861 for the first offense for substantive violations or uncorrected technical errors. And then there are fines that are assessed for recruiting, referral, and rehiring violations, in which the penalties range from $716 to $5,724. Again, for first offenses for each knowingly employed unauthorized worker. So the fines go up if this is, second offense or subsequent offense, right? So if a company, had an I-9 audit, 6 years ago and HSI is back, if the company was issued a notice of intent to fine under that first audit or even a warning notice, they could be subject to the higher rate of penalties if there is a fine or if there are substantive violations during that second I-9 audit. And those violations, the penalties are significant. They go from a little over $5,000 to over $28,000 for those offenses. Now, going back to 2019, which seems like forever ago, um, ICE conducted 5,981 I-9 inspections and they reached $14.3 million in fines, penalties, and forfeitures. In fiscal year 2024, ICE conducted 264 I-9 inspections that resulted in notices of intent to fine totaling more than 17 million, of which 4.5 million has been collected. So what happened is HSI, is the one that enforces the law, and HSI has kind of rebranded themselves, so they're not ICE, they're definitely just HSI. They have significantly reduced the number of audits over the past 3 years, but they were very targeted. So we had some questions asking about targeted industries, and Carrie, your sound broke up just a little bit, so I'm gonna mention that those targeted industries can be food packing, manufacturing, hospitality, construction. Agriculture might be a targeted industry as well, but those tend to be the targeted industries. And what happened in the last few years is that HSI was going after organizations where there have been complaints or they knew that there would be a high number of undocumented workers or errors, substantive violations with the Forms I-9. So they were able to, in a way, kind of keep the amount of fines almost equivalent to what they did where they were conducting just under 6,000 inspections. All right, so next slide, please. This is an example of a matrix. basically what happens is that that range that I provided, in order to determine what part of the range is going to be used for the actual fine amount, ICE uses this matrix and they look at the percentage of Forms I-9 that have those violations. So a company could have the same violation on 50% or more of their Forms I-9, and they're going to get hit with a higher fine amount starting at a little over $2,000. Now, these are the numbers based on 2023. We have not received an updated matrix from HSI at this point in time, but just know that the amount of the fine is based on the percentage of Forms I-9 that have the violations. So the greater the percentage of I-9s that have violations, the higher the base fine for those violations. Criminal penalties could be warranted in certain situations. Typically, that is where there's a pattern or practice of hiring, recruiting, or referring for a fee those unauthorized individuals who are at the work site. So that's pretty rare to have criminal penalties, but it is something that ICE does look out for, right? I-9 compliance during emergencies. And there have been several emergencies lately over on the East Coast with the flooding here on the West Coast with our fires. And USCIS and HSI, they've provided guidance on their website. Employers must still complete Form I-9 even during natural disasters. If the I-9s are lost or destroyed, they need to be completed, and a note should be included with that process saying that the original Form I-9 was destroyed. When was it destroyed? What natural disaster was it? And then the other side of it, right, is that employees might not have valid documents because they've been lost in the natural disaster. So they can use the receipt rule for lost or stolen documents, meaning that that receipt can show their identity and or work authorization for up to a 90-day period of time. And then at the end of the 90 days, they have to have a document to show their valid identity and or work authorization. And then E-Verify cases are delayed until the original documents are available if you're using that receipt rule. So that's something to keep in mind as unfortunately more and more natural disasters occur. And in one of the things, right, as Carrie mentioned, we're expecting an increase in ICE or HSI audits going forward. So one of the things that companies can do to be proactive is to conduct internal I-9s. And when conducting internal I-9s, we recommend determining the purpose of the I-9 audit, right? Oh, because we want to make sure that we're compliant. Determine the scope of the I-9 audit. Either do a review of all of the I-9s, or it might be good just initially to start with a subset and see where are the I-9s in pretty good shape, or do we have a situation on hand that we're going to have to dig in and spend a lot of time with remediation. There also should be a communication with employees so that employees understand that if they're reached out to by human resources, that this is why they're not being targeted is not a discrimination issue or retaliation for anything, but rather it's part of the internal compliance process of ensuring that everything is in order. And then there always, always, always should be a process that has been created for correcting errors or omissions found on the I-9 audits so that whoever is working on the project does everything consistently and orderly. Over to you, Terry.
Thank you. And I think what the theme is here, am I frozen again? Can you hear? I think what the theme is here is to plan, um, and just be prepared. Uh, in in terms of conducting an audit, you want to engage outside counsel, because everything that we communicate and review is privileged, and we'll help you review your policies and procedures. Kimberly and I have been astounded over the past 5 years at how many versions of the I-9 have been introduced, and how policy has changed, how the rules have changed really as a result of COVID, and remote work. And so we really want you to review your policies and procedures because there's been a lot of changes. Um, and then, train new employees on how to complete I-9s. We're always surprised at the fact that I-9s are, again, a critical piece of onboarding, but it is a legal process. It is a regulatory process. It's like filing tax returns, and so it does require a high level of training and expertise. And so, best practices for a company to have a center of excellence around I-9 compliance. Of course, not all companies have the resources for that, but as best you can, you need to have expertise connected to your I-9 compliance. And then, you do need to have a clear process for a notice of inspection, primarily because there's only 3 days to respond to that notice of inspection. And if you are over that 3 days, then you're already in violation. We can go to the next slide. So key takeaways in terms of the HSI enforcement action. Again, you want to have a plan. This is repetitive, but plan, 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 plan. Again, train your HR employees on how to handle um, door knocks, notices of inspection. You want to retain compliance documents, conduct internal audits. We recommend annually. Every 2 years would probably be okay. But we are recommending at this point, if you haven't done it in the past year, it's a great time to do it. And, you can either do a company-wide I-9 audit, or you can do like a percentage. You could do like 15% just to identify patterns of error patterns and then to remediate those patterns. Or you could do like a location-based I-9 audit for your sort of higher risk locations. And then, of course, again, anything that you connect with outside counsel on is privileged. And so you have that higher level of protection if you engage outside counsel. We can go to the next slide. Let's talk a little bit more about electronic software. And somebody had asked, I froze up a little bit, but somebody had asked, can you photocopy an I-9 and then store it and get rid of the paper I-9? Yes, you can. You can do that. And as long as the I-9 is photocopied properly and stored properly according to Department of Homeland Security's requirements. But we just want to make sure that we're compliant. We can go to the next slide. So, the Department of Homeland Security over the years has published a certain amount of guidance to this, but it's still more of an art than a science because E-Verify is still more of an art than a science. But there is a lot of engagement around this, and this is why I like working with Kimberley because she's the chair of the Verification and Documentation Committee of ALA. So she meets with E-Verify leadership and HSI leadership. And so we do have some good ideas, and we do know how to compliantly store electronic documents, and we do know about the audit trail. And of course, the foundation is the statute and regulation at 274A, right? And then you have the internal guidance issued at ice.gov. And of course, we have case law, right? I mean, we look at companies that have been fined tens of thousands or hundreds of thousands of dollars because I-9 software is not a shield. It will not protect you. E-Verify will not protect you. E-Verify will not protect you, okay? It creates the rebuttable presumption that you're compliant. However, if you're not using it properly, it is a window into your non-compliance, all right? And it creates a whole additional process that an employer has to police. So sometimes E-Verify the best option for an employer if an employer doesn't have the resources to police it. So in terms of keeping your I-9 software and security requirements compliant, make sure you have a secure database, electronic summary file, spreadsheet, passport protected unique use profiles, backup redundancy indexing, confirmation of electronic signature at the time of transaction, and audit trails. This confirmation electronic signature at the time of transaction is very important. The person, you have to have a particular PIN for the person certifying Section 2 and the person certifying Section 1. If you don't have that, it's as if the I-9 was never done electronically. So, I-9 software should have all of these things. When you're purchasing I-9 software, you push the burden on the vendor. The vendor has to um, assert compliance and has to show you how they're compliant. Um, because again, I-9 software is not a shield. As the user, as the employer, you are liable. You can go to the next slide. State investigations. I'm going to hand it over to Kimberly.
So you can go to the next slide, please. So there are various states that have laws that relate to E-Verify compliance, right? Some states require that all employers in the state be enrolled in E-Verify for those employees that are employed in that state. Some states will require that a company participate in E-Verify if they have a contract with the state or a contract with a certain government entity within that particular state. Each state varies, but there are more and more states now that do have some type of E-Verify law on the books. So if you are an organization operating in any of these states, one of the things to check is, are you in compliance, and does that E-Verify law actually apply to you, to your organization? One of the more recent ones is Illinois, that became effective on January 1st of this year. And that law in E-Verify, it doesn't prohibit E-Verify in Illinois. So let me make that clear. There was a lot of information out there on the internet that said that E-Verify was making it, essentially unlawful, or that employers could not enroll in E-Verify, but that's not the case. Employers may enroll in E-Verify in Illinois. Illinois does not mandate enrollment in E-Verify, but if a company is enrolled in E-Verify in Illinois, they have to comply with certain requirements, such as certain notices that must be provided to employees and insurances that the organization is in compliance with the federal E-Verify guidelines and rules. So that's one of the newer things with E-Verify in Illinois. There are some states that are active with E-Verifying investigations. What does this mean? It means that if an employer is, located in North Carolina, Florida, or Tennessee, we have seen that there is an increase in the states that are conducting E-Verify investigations, requiring employers to provide information about their E-Verify cases and their I-9 documents. There are certain reports that are being requested in these investigations that an E-Verify employer cannot just pull down from their E-Verify account. So they can contact, and actually have to contact, E-Verify customer service in order to request those specific reports, and E-Verify will provide those to the organization. So these are states where we notice that there are active investigations. So just be, aware of that if you are in any of those states. Okay, next slide. So E-Verify Plus, this has gotten a lot of attention lately for companies that are enrolled in E-Verify. You may be seeing a lot more notices from E-Verify touting E-Verify Plus. It was previously known as Next Gen, and just about a year ago, it was renamed E-Verify Plus. They being USCIS, is considering this the quote unquote future of I-9 and E-Verify, which is in essence putting the two processes together. So initially there was a pilot group of 10 employers in April of 2024. Now there are more than 1,000 employers that have asked to participate in E-Verify Plus. What E-Verify Plus does is it has the Form I-9 completed online electronically, and the employee puts their documentation, provides their documentation, and the information is run through E-Verify. If there is a tentative non-confirmation, E-Verify works directly with the employee to resolve that issue. So it takes the burden off the employer. One of the things to consider is that, this is not a replacement for the Form I-9, and it's still completed. It's just that the E-Verify component is now being taken care of by E-Verify directly. But an employer is required to actually retain those I-9s that are completed, because they're not going to be retained on the E-Verify site. And what's also important to note is that the audit trail for E-Verify Plus with the completion of the Form I-9 has not yet been approved by HSI. So there could be issues with compliance for purposes of those audit trails if an employer uses E-Verify Plus. So as wonderful as this system might be, it is still kind of working through the kinks, and hopefully it is something that becomes the future, that makes it, easier for employers and less burdensome. But who knows? But right now, our recommendation is before diving into E-Verify Plus, to talk to an attorney about, how that would impact your workforce and your compliance.
Um, so yeah, we have some great resources that are publicly available. You can take a picture of this slide or a screenshot. Kimberly and I are looking at government resources every day. And we're actually deep into these issues as well. Um, you know, Advising on raids and I-9 audits and any kind of worksite enforcement is really a daily occurrence these days. We've seen worksite enforcement actions all over the country. And so we're actually putting together a toolkit that we'll have available in the next few weeks with templates, FAQs, even videos for FDNS site visits and role playing. So definitely connect with us. Again, we'll have that available probably in March. And then beyond that, any questions you have, we even like to review, ID documents, work authorization documents. But one of the trickiest things that we're running into these days is the fact that TPS and humanitarian parole is expiring, and there will be, thousands of people losing work authorization. And so employers really need to pay attention because EAD expirations, work authorization expiration is a fact. And so you need to get your I-9s in order. And with that, Kimberly, do you have anything to add?
You said it all right now. I honestly was answering a couple of these questions. So I know we talked about this, so you've presented everything that we were talking about. So I don't have anything to add there.
Yeah, and there are some really, really great questions. A lot having to do with E-Verify. E-Verify is its own animal. E-Verify does desk audits. You want to make sure that you're also auditing E-Verify. An E-Verify number has to go on each I-9, or the E-Verify case readout has to be stapled to or included in each I-9 file because it's part of the I-9 process. So just make sure you're also E-Verify compliant as part of your I-9 compliance. It is part of the I-9 compliance. Remote employees follow the rules for what state, where they live, or where the employee is housed. You know the answer to that one?
I know for Florida, it's based on where they are located. If they're a Florida employee, you get into different situations where you might be able to state that the remote employee is overseen by the hiring location, which might be the corporate headquarters. So that can get a little bit tricky. I don't have an answer that fits every situation. So that's definitely something to look into a little bit more to understand um, how the employees what's the hiring structure, in order to determine where they're considered to be, as well as looking at each individual state law.
These are great questions, and we look forward to following up on our March 12th webinar, which is part two of this series, where we'll go over the agencies, including Department of Labor, FDNS site visits, and much more.
Thanks everyone for attending. And if you submitted a question and we have your name there, we'll be able to reply to you. And if we weren't able to get to your question, please feel free to reach out to us. We'd be happy to answer that for you. Have a wonderful day. Great to see you, Carrie.
Thank you, everybody. Thank you. Bye bye.